Hello, Dr. Francisca Anene here, and you're welcome to PPL324 Law of Thoughts 2. I'm sure you have enjoyed our previous lessons and you have enjoyed watching the instructional videos. And beyond enjoying, I hope that you have learned something. In fact, a lot of things. So, we're going to be learning something new again in this video. We're going to be taking another important topic in law of thoughts. And as usual, I'm counting on you to pay attention, to take notes if you have to take part in the activities, think about what you will hear, and try and learn whatever lessons are available to be learned. Okay, so let's go. So this is our fifth lesson, and in this lesson, we'll be looking at defenses to defamation. The main thing you should have learned by the end of this lesson will be the defenses a defendant may raise in opposition to a claim of defamation. There are four major defenses. You have justification, fair comment, privilege, and res judicata. So let's go over them one after. Justification, the other is also it also means truth. Basically, what the defendant is saying is that what he said, which the defendant, is alleging that is defamatory, is the truth. In other words, whatever it is that he said that, impacted on the defendant's reputation is actually in existence. So the defendant has a bad reputation, and so he has not suffered any damage from the bad reputation. He can be compensated for having a bad reputation. And it's important to note that the fact that all the facts don't add up may not defeat the defense. So if there are minor inaccuracies that don't materially injure the plaintiff's reputation when compared with the truth of the defense, then they will not affect the defense. Second defense is fair comment. Fair comment is a dispassionate expression of opinion on a fact or matter of public interest. So the basis for fair comment is public interest. And so it's important that freedom of expression and press freedom are protected. So that's why you have this defense. And in order to succeed in a claim, a defense of fair comment, it must be clear that the statement was a comment or an opinion and not necessarily an assertion of fact, and that the comment was a matter of public interest. Also, that the comment was honestly made and was not motivated by malice, and then it was based on facts truly stated. So you cannot wake up and tell a lie and then comment on it and want to come under the defense of fair comment. And you see, fair comment is similar to justification, particularly the fact that the comment is based on facts or the truth. But it's important to note that there are two different defenses. So where a party wants to plead, both fair comment and justification, he can't rule them in one. He must plead them separately. And okay, let's take our activity. So I want you to answer this question. For a defense of fair comment to succeed, what must the plaintiff prove? Our third defense, you have the defense of privilege. The whole point of privilege is, yes, the statement was defamatory, however, you're protecting it because of public policy. And there are two types of privilege. There's absolute privilege. In other words, there's absolute immunity no matter what has been said. And then there's qualified privilege. So usually, absolute privilege protects statements that were made in formal, official public proceedings, like proceedings in courts or reports on them, proceedings, in parliament or reports on them, communication between officers of the state, and communication between a legal practitioner and client. Type of privilege is qualified privilege. it's not as absolute as absolute privilege. So the whole point of qualified privilege will be, to protect statements that were made with honest belief in the truth and no malice involved. So the issue is not whether it was really true, but the person who made the statement honestly believed it to be true and was not malicious in making it. So the statements made in self-defense, performance of a legal, moral, or social duty, made by parties with a common interest, made about judicial and parliamentary proceedings, or statements made to obtain redress from law enforcement officials will come under the defense of privilege. And to the last defense is the defense of res judicata, simply that the matter needs to end. Let the matter rest, right? So you have litigated this issue before. So and the issue was, finally decided by a court of competent jurisdiction. A party won, a party lost. Well, that's the way it is. So for this claim, this defense to lie for a defendant, he must establish that the case was contested before a court of competent jurisdiction, and that the parties were the same, and a final decision was reached by the court, where the plaintiff either won or either lost, and so on that basis there should be an end to litigation. So where these elements are present, then a party will be stopped from going again to file another case of defamation activity. I need you to differentiate between absolute and qualified precedent. Okay, we have come to the end of this lesson, and we have learnt about the defenses that may be raised in opposition to a claim of defamation. As we said, there are four major defenses. You have justification or truth, you have fair comment, you have privilege, which can either be absolute or qualified, and you have res judicata. You can always download the video and watch it again and again to deepen your knowledge. But please post it on the discussion forum, and then we can try and answer it. So until our next lesson, thank you very much for taking part, and see you again.